Thank you so much for tuning in. You are just in time to catch us here on 3T TV, Thika's #1 online news channel, where we are telling the Thika story as it is. My name is Juliet Modhoni, and today I'm bringing you yet another informative episode. We are in the company of a learned friend, and we are going to dive into children's law. You know, we as parents are mandated by the law to do a few things, but we probably don't take them seriously. We are going to learn more about that, and I hope that if you haven't subscribed, this episode will give you a good reason to. So let's dive right into it. How are you doing?
Fine, thank you.
Thank you so much for finding yet some other time to talk to us. Kindly introduce yourself.
My name is Mwenda Njagi. I'm an advocate of the High Court of Kenya. I'm also a judiciary accredited mediator based at High Court Milimani, Nairobi. I work in the name and style of Mwenda Njagi and Company Advocates, and I'm situated at Seattle City Mall, Kiambu Road, Block A, third floor. My mobile number is 0718 810 300.
Thank you so much for that. Today I'd like us to talk about children law. And before we go any further, kindly tell us, what does the law say about the responsibilities of a parent?
Thank you, Juliet, for that question. The responsibilities of a parent usually comes with the duties that are involved that are heaped to the parent, to the child. And some of those responsibilities have to be looked into the context of the rights of the child, because it's upon understanding the rights of the child that then you ask yourself, who is supposed to provide for those rights? And basically the person supposed to cater for those rights, it is the caregiver, the guardian, or the parent. And among the rights of the children, which now translates to the responsibilities of the parent, is you have a right to a name and an identity as a child, which now is the responsibility of the parent to give the child a name, say through baptism or through cultural naming and practices. You also have to be provided for through nutrition, good care and protection, maybe from harmful practices, like our girls who may have been undergoing FGM. The parent is supposed to protect you from those kind of cultural activities which are ousted by the law. There's also the question about care and protection from actual harm, which may be physical or psychological. So as a parent, you have a duty and a responsibility to ensure that your well-being of your child is provided for in the law and the Children's Act.
Now, when we were learning in school, mostly what we learned was father, mother, children. But there are circumstances that come about and you find that there's a single mom or a single dad. What is the place of single parents in law? Are their children any lesser?
That's a very good question, because there is a rampant rise in a society of women who may be described as the modern woman who is able to do both, being act father and act mother. But even the other side, even the converse is true. There are also those kind of men who feel that way. The question about a single child should be, because the issue that arises, the single child has been branded as an illegitimate child. But among the considered school of thought that we don't have an illegitimate child, what we have is illegitimate parents, because the child by and large is innocent in terms of the choice of where he or she would be born. The answer to that question is the child, in spite of either having both parents, being born among both parents, or being born by a singular parent, who may be called a single parent, has equal rights just as a normal child. So that child is not any lesser. He has a full protection and care under the law, and has a full rights which accrue thereof. Because when you look in terms of the child, there is no clear-cut line or distinction in the Constitution that says because the child is born into a monogamous union or a traditional family has more rights than this other child who is maybe born by a single parent. Because maybe the upshot, and as we move on in this discussion, what guides matters of the children is basically what we call about the best interest of the child. It's about the child, it's not about the mother, it's not about the father. So that what is best for that particular child, because each case of a child should be looked like an individual case. Even if you have like 5 children, each child is independent, and if there is a question before the courts for determination, it breaks down those issues into singular form to determine what is good for child X may not necessarily be good for child Y, so that those are things that we should look into.
So that we find a balance.
A balance, yes.
Now, you've talked about the best interest of the child. Then there are these cases where we have a deadbeat dad or a deadbeat mom. These are people who do not want to take responsibility. What is the way forward?
I'm happy you've also included the deadbeat mom.
Yes, they're there.
Because usually it's a boy child who has been on the receiving end.
Sure.
And the issue at hand is that Article 53 of the Constitution provides, and it's very clear, that a child should be provided by both the mother and the father, whether they are married or not. So the notion for you to come and say, I'll not provide for this child who you have not disputed in terms of paternity, but I'll not provide singularly because I'm not married to the mother, or because I divorced the mother, or because I separated to the mother, or maybe because maybe the mother is no longer conceding to your advances, so that now you withdraw. That one has no basis in law. The child should be provided for both parents, whether they have married or not. So the place of the parents who don't take responsibility lies in 2 ways. One, you could report to the children's officer, who is the easiest, maybe somebody who cannot approach the court of law. Those children officers are found in the district service areas, like in the DO's office or those kind of community areas. You report. Upon such a report, the Act empowers the children's officer to summon the deadbeat parent, and you are told, can you show cause why you should not be committed to the sanctions of law for not providing for this child. So upon such summoning, you can say, look, my income, maybe through an affidavit of means, what you call an affidavit of means, my income is 20,000, I pay rent of 5,000, I have another wife, I spend another 6,000, so my disposable income maybe is 10,000. So maybe what I can afford to provide for the child is say 8, because you should also not be punished. You cannot use a child to maybe enrich yourself, and that's why you see the deadbeat issue arising, because some parents feel that the other parent is taking advantage of me, not for the purposes of benefit of the child, but to unjustly enrich themselves. It's not about the 2 grown-ups, it's about the child, and you should not be punished for what you can't afford. And if most parents knew the importance of even submitting yourself to the children's officer, submitting yourself to the court process, and you come and tell them, this is how much I earn and this is what I can raise, so this issue for deadbeat would be a matter of the past.
Awesome. Thank you for clearing the air, because there are people who usually take advantage and milk the cow dry. Now, in case there is a divorce, who should have the custody of children? What ages are we talking about?
That's a very relevant matter, because usually when 2 consenting adults celebrate a marriage, nobody envisages a divorce. It is usually the happily ever after.
Sure.
But those things may be inevitable. A divorce can arise, a separation can come, and maybe a desertion. Somebody can also leave you. It can also happen. And the culprits, or the people who may end up suffering, is the children, because they were accustomed to a lifestyle of both parents. There is a conflict in law, and I need maybe to tell that to the viewer, because the Constitution talks about equality before the law. That is Article 24, that all people are equal before the law, in spite of gender, which is include whether you're male or female, irrespective of religion, irrespective of your creed or any income. So there is equality before the law. But when you come to the Children's Act, Cap 141 laws of Kenya, it is that children of tender years. Usually tender years, we talk about maybe children below 7, or children who may be needing actual nexus in terms of provision by the mother, like suckling children or those kind of children who may need direct or more need or they may be not needing more care to the parent. What the parent here referring to the mother, that ordinarily they should stay with the mother. It even goes ahead and talks about gender, like he used to do with maybe the girls. They may consider it may be the mother who may actually stay with them better. But that one conflicts the constitution, which talks about equality, because now the man can also come and say, look, it should not be automatic that the mother should get custody in spite of the mother being a drunkard. She may also be somebody who is irresponsible. She may also be somebody who is absentee mother, so that absenteeism has a direct nexus and affects the children. And maybe the father is well and concerned about the welfare, so that you should not be discriminated by virtue of your gender. It's not automatic, because that particular section of the law, my reading of the law, it conflicts with the constitution, and the constitution is more superior, and the constitution says we are equal. So that when the divorce happens or when separation happens, if you move to court, meaning if you file an application to court, you should be heard not necessarily because of your gender, that you should be favored by virtue of your gender. The court should be cognizant of Article 53 of the Constitution, which says it's about the best interest of the child. And how to get the best interest, maybe to expound on that topic, because that's a very important topic. The court has a power to send somebody called a children's officer. A children's officer can be sent to your house, can be sent to your home, house or homestead, maybe if you are living in a community, your place of work, and comes and assesses how you live. He can come to the side of the mother and goes to the side of the father. He or she can also interview the children, because the Act also wants to hear what is the opinion of the children. And the children of nowadays are very informed.
Yes.
They can easily say, I'm more comfortable with my father, or I'm more comfortable with my mother. And those things should be taken cognizance by the children's officer. So with that report now, she files to court, or he files to court, which now guides the court to make a more determined opinion. Because the matters of the children are unique, because you see, when you file a case in court of a children's case, you file like the child, let's call her Jane. Jane is now suing the father or the mother, but now is coming through Juliet. So Juliet as next of friend or next of kin to Jane. So it's a children's matter. It is about the child, not about the parent. Now when the children's officer comes and looks at your house and looks at the circumstances, because you should also look at the condition, because you see when a divorce happens, lifestyles may change, because maybe this children was accustomed to a certain kind of lifestyle. Maybe was accustomed to live in a neighborhood which is affluent. Now that divorce has happened, maybe the mother has gone to a lesser area, or the father has gone to a lesser neighborhood. So the court should also look. You don't want to destabilize the child. The child was used to a certain lifestyle. There's also the issue of schooling, because now if the divorce has happened, one has left and maybe is out of town or near the vicinity of the school. Those are things that the court takes cognizance. Interestingly, the court also, on its own motion or upon a request by any party, can also summon the children to come to court and say, I've looked at the children's report, I've looked at your pleadings, which you call the documents you filed in court, and I would also wish to do something more. Can the children be produced before me? So the court interviews the children and may want to know the circumstances they are in, how they are faring, and the court will pronounce itself or give directions to that extent. That is the power of the law.
Now, I think you've already answered my next question was about the gender of a child. Does it matter in a custody case?
Yeah, I need maybe to say more deep on that, because the question about gender should be looked into the context of the needs of the child. And we had said that a child's needs may vary.
Yes.
So that now, if the gender is a girl child, and maybe you are a father, you are living with men, you have a houseboy, the court may be hesitant to give you custody of such child of tender years, especially girls, because of their the exposure they may be having. But it's not a question in isolation, because you should also draw the nexus, because you can also be living with women, a house full of women, but they're not providing for the child as well.
Yes.
as this man. But maybe if the man maybe has a house help, maybe the man has gone and married and has a fairly accommodative spouse who is assisting. Those are things that mitigate and assist the court to make an informed choice. But to answer your question, plain and simple, children of tender years usually stay with the mother, and especially girls. But if the circumstances are different, then the court should not be giving a blanket order. Now that it's not satisfactory just to come to court and say, look, I'm the mother, so I want the children. This man to pay. That one would be tantamount to jungle law.
Yes.
Because you're discriminating one by virtue of gender.
Yeah.
But the general rule says that. But of course, we say in law, there is what the law says, and there is the exception. The general rule is that they should stay with the mother, but if the circumstances are different, which can happen, so it's upon you not to prove the circumstances. For example, you could say maybe the mother has gone ahead and remarried,
Yes.
and maybe the children were accustomed to the both, so they're seeing a different stranger
Yes.
in the house, and maybe they may want to stay with the father more. It's different now if the mother was not remarried, because there are some women who go and remarry, and now the children are not comfortable because they were accustomed themselves to a known father.
Yeah.
You could also say that maybe this woman is responsible. Maybe you've given her aid, but that aid is being given to the new boyfriend.
Yes.
Maybe you have given a small car to take the children to school, but instead of the car being used, it is being used by the boyfriend. Or maybe she's an absentee mother.
Yes.
Maybe she's this woman, in as much as it may be good, maybe overly religious, which accept the welfare of the child, because absenteeism does not necessarily have to be negative. It doesn't mean to have to be in the bar. It may also be
In church.
or religious places,
Okay.
which affect the child because they don't have that care protection. Or maybe when you weigh, the father may do better than the mother. So the court can say, the father can stay with the children, but because at the end of the day, still the mother, she'll have access. That access maybe can be supervised or unsupervised. Maybe we'll discuss that later. What access maybe it's all about.
Yeah. Awesome. Now, in case there is a divorce, who should pay for maintenance of a child or the children? Who is responsible for making sure that, these children are provided for food, clothing, shelter, seeing to it that now we are not together?
That's a very good question as a follow-up to the other. It goes back to the Article 53, which is that a child should be provided by both the father and the mother, whether they are married or not. Because upon the divorce, you are no longer married. You can now go and transact another marriage. If you have another man who suits you, you can also transact another marriage with a woman who suits you. But the child has to be provided for.
Yes.
The person to provide is the two of you, because the court have made it very clear that no person should be made a beast of burden. Not because that you are the man, you are the one to cater for everything. No. The question is not about, it's not for you to bring 50-50, but proportionate. For example, the man's salary is maybe 100,000. Maybe the girl's salary is around 20 or 30,000. You should not punish the woman by telling her, I'm going to take the child to a high-end school, so you'll be bringing 50,000 for a term. The school fees is 50,000. So you'll be bringing 25, and they'll bring 25. It's not about, no. Because her means is a bit low, you could say, I'll be paying school fees, you'll cater transport. Or I'll be paying school fees, you'll cater for extracurricular activity. But there should be actual contribution. It is not enough for you to say, as a father or as a mother, I want to be involved in the life of this child. You want visitation, you want to see, but you don't want to remove a penny.
Yeah.
So, what is good for the goose is also good for the gander.
Sure.
If you want to be involved, then you should show some meaningful effort. And that effort should not be used like throw away, not just as a show of contribution. It should be actual, tangible, and meaningful contribution to the child. So if the two parents have divorced, and that's a very bitter thing for any couple, because people go through those kind of challenges, you rise up and you understand that the child has to be provided for. One parent has to be stronger, and one has to be in charge. So you have to provide for the child in terms of what you're able to provide. It should not be a question of punishment. The other thing also happens whereby, upon the divorce, the other parent, in this case let me give the woman now, wants to punish the man. So you put now the children to very high-end schools because you want this person to pay dearly, or maybe you feel that he should not have anything to spend, and you feel that maybe that's the best way to do. If that's what you want, fair enough. We could say we'll cap the fees to 50,000. If you feel that you want to take your child to do those international system and you pay 150, I can only afford 25. So over and above, you go and pay. That's a very good reasoning and allowed for, because that way now no person would be made a beast of burden, and if somebody wants to live that kind of lifestyle, then they can go ahead and live. But a child born in a divorced family is treated differently from a child who was born by parents who are never married. Maybe I need to say that to the viewer, because a child who was born in a family that was married has some benefits which may not necessarily be for the other one, and I'll give you 4 of them. One, this child had been accustomed to a certain lifestyle by both the mother and the father. Maybe they used to this kind of neighborhood. So if you have divorced, you cannot now tell the mother, you now live from neighborhood X, which is very affluent, now go and live at the slum because you're no longer mine. The court would not hit to that because they had a certain level standard. The second test, that is because now that is different from the other child, because a child has no standard at all. You have never lived with them, so you cannot be told upgrade them and bring them here. So that's maybe something that you should consider, because sometimes you see matters that you read in the newspaper, and you see because somebody somebody may think they hold high public office, or they think it's a man of means, you hit them with a fee note which you yourself was not raised to those standards, or neither you can afford nor is it feasible. The matters of the children should not be used to unjustly enrich yourself as a parent or as a caretaker. It is basically what is right for the child.
Awesome. Now, we have talked about parents having responsibilities. What consequences face a parent who doesn't, provide for children like the law states?
Thank you. If you don't provide for the child, the court has a way to make you provide, and there are several of them. One, the court has the right to be heard, because you cannot be condemned and heard. So if you feel one parent is not providing for the child, what you should do, write to them formally, because now when you're preparing, a good case is as good as its preparation. So you prepare through a letter or a demand letter or a letter inviting them for mediation. You can go and look for a mediator, or maybe a parent or a loved one or a church elder or a chief or even a children's officer. All these things may be free. It is not expensive as somebody may think. Or you can also go and look for a lawyer. So they do a letter, a demand, pay this and this within 7 days. If the 7 days happens if you're in the same jurisdiction or same area, or pay within 14 days if you're in different towns. If you don't do, I'll approach the court. Having done that, the person may reply and say, look, I'm agreeing to 1, 2, and 3, but 4 and 5, I'm not able to pay.
Sure.
I can pay school fees, I can pay for medical, but you deal with your house rent, because I'm not coming to that house. Deal also with at least some shopping, food, because I'm not eating that house. So you say, no, but the child has to eat. So you go to court now for determination of 2 items.
There's also a house girl.
And the house girl now, the house girl, yes, and electricity and power.
Yes.
So all those things, they are listed, and maybe you could agree on a few. Once you don't agree, the court will determine. Or also you could have a full consent. You could agree on everything, and you record it like a parental responsibility agreement. In event you don't agree, that's why the courts are there. You approach the court and you tell the court, look, I'm the parent. Usually it's the women who rush to court, but also there's nothing stopping also a man to go, because you have the equal protection of the law. And you tell the court, look, I'm the mother, the father has refused, and the child is suffering. The court, what it does, it tells you to prepare summons. Summons is now like an order to appear within 14 days. You either come yourself or you come by representation by an officer of the court. An officer of the court hereby meaning a lawyer or an advocate for purposes of court processes. And you have the right of reply and say, I'm not disputing paternity, or if you're disputing paternity, you could ask for a DNA. Because you may also be thinking, I'm being dragged to court by this lady, and I'm doubting the paternity. So the issues also arise during paternity. And one of the issues that arises, who will bear the cost? So there are two schools of thought. You could say, since I'm the one who's asking for paternity, you as a man,
Yes.
so you cater for the cost. Then another issue arises now. Which hospital? Because you may be arguing that
Yes.
hospital X, maybe there's a friendly doctor,
Yes.
and there is even instances whereby specimens are taken to two different institutions to avoid doubt.
Yes.
That tells you the seriousness of this matter. And remember, these are very emotive issues, because they are issues that touch on somebody you had shared a good time with or a good moment with. So they should not be taken lightly. And the other thing now, the question about paternity can be disputed or undisputed. If you're not disputing paternity, about now the issue maybe who is the father, then you now go to the main issue about provision. The court hears you and gives you a chance to respond. You could come and say, I'm able to provide, but right now, due to COVID pandemic or 19, I've been made redundant, or I'm not in such meaningful employment, or my income patterns are as follows. What I would like the viewer to know, never ever refuse to submit yourself to the court process. Because if you don't, you'll have a field day for the opponent, because now she'll have an undefended case. But you have the chance to come and say, I'm able to raise this much, I'm able to get this much. So upon such conclusion, the court now gives something called a ruling and gives interim directions. And the matter now is fully heard and determined, it gives a judgment. Many other times, somebody may be told, pay or provide to this extent, and you refuse. If you don't now pay, you can now file something called a notice to show cause. You say this person was told to pay, he has arrears, because also you should backdate from the time of judgment. You are told to pay 40,000, it's now 6 months later, so you owe me 240. So it is in arrears of 240.
Yes.
Can he pay? If he doesn't pay, two things happen. You can be committed to civil jail, or you could also garnish their salary, especially to somebody who is employed.
Yeah.
Like if you're employed in a very prominent TV station like 3T TV,
Yes.
you could go to the boss and tell them, I have this garnish order, so whatever salary this woman or man is earning, slash it to this extent. But it becomes very hard for the men in Juakali, because he may be a tycoon, but he has no known source of garnishing the salary or the incomes. So that now the child has to be provided for. So those are the enforcement mechanisms that are available for in law. So somebody should not feel that you'll have an order and you won't enjoy the fruits of your order. The law is very elaborate on how you are going to attain the orders of such a judgment. You should enjoy your fruits.
Wow, that's quite informative and quite a lot to wrap around your head. Now, as we come to the conclusion of this wonderful discussion, there's probably some advice you'd like to give. There are probably two parties that kuna mgogoro mahali ya mtoto. What advice would you like to give them on how to go about it?
Thank you. Maybe the upshot of my advice would be that a child under the law is anybody below the age of 18 years. And they are special beings who need special care and protection. And the first point of such care and protection is the parents. But sometimes the parents may not be seeing eye to eye. Sometimes it's good to put your differences aside for the benefit of the child, because the child also needs such kind of protection.
Sure.
And even if you don't like each other, you can bend backwards to ensure that that child is provided for. Provision through their needs, and also allowing the other parent. You may not like the other parent, but allowing them to see the child,
Sure.
because the child actually needs such kind of provision. And if you are given such kind of access, don't go and hide the child, because some parent, you give them access, but they don't show up tomorrow, they switch off the phone. So you should have an element of goodwill, if such kind of sustenance, and for the benefit of the child. Thank you.
Thank you so much for that very informative session. I think you had given your phone number.
Yes, I have.
In the beginning, and we thank you for your wise counsel.
Thank you. Thank you.
Ladies and gentlemen, that was Peter Mwenda, who is an expert in matters mediation, and everything all boils down to integrity. If you and I are able to, carry out our lives with integrity, we will be able to live very good lives. I have been your host, Juliet Modoni. Until next time, take care.